Hello and welcome to the next in our series of webinars aimed at helping HR, business owners and managers. Thank you for joining us, whether live or using our Listen Again facility, and I hope that you are well. Our webinar programme continues our focus on workforce planning issues by looking at changing terms and conditions of employment. Now, this was a topic which has been raised by our previous webinar audience through their feedback as something that they want to hear more about, as well as questions that we've been receiving as part of the employment team as well from our clients. As businesses begin to bring staff back to work from furlough leave or are looking at ways in which to reduce costs, employers are now asking, how can we change a contract of employment? Just to remind you, this webinar is an overview discussion looking at general principles and is not intended to be a substitute for taking legal advice. All businesses and contracts are different. Just a bit of housekeeping as well. This is a live webinar, so you will all be in listen-only mode. Do let us have your questions during the chat panel, and we will do our best to come back to you either live or after the broadcast, depending on how much time we have. Today, I am really pleased to be joined by my colleague, Andy Whitaker. Hi, Andy.
Hi, Emma. It's good to be with you today.
I think it's fair to say, and probably an understatement, that we as an employment team have been incredibly busy over the last few months supporting employers at this time.
Yeah, that's absolutely the case. It's really been a time when employers have been having to make decisions quickly in terms of placing employees on furlough, making adaptations to facilitate remote working, and also ensuring their businesses can survive, particularly as we move into sort of phase 2 of the job retention scheme and the gradual tapering off of government support and the end of the scheme at the end of October.
So, as we've said, the purpose of this webinar is to raise awareness of the issue of changing terms and conditions of employment. So what we want to focus on is when might an employer want to change terms and conditions? How would employers look to change those contracts, those terms and conditions? We'll look at temporary versus a permanent change and where there might be some changes there. Have a look at some of the issues, risks, problem areas. We also want to look ahead and also talk to you about how you can use your contracts more strategically as business tools and what clauses that you might want to look at as having as part of your suite of documents. And then we'll also have a look at some practical issues and pointers as well. For all those who are looking at issues around grappling with the government guidance on the job retention scheme, COVID-19 risk assessments or holiday pay changes, the good news is that when we look at changes to contracts of employment, the law hasn't changed. So it hasn't been changed by lockdown or other measures that the government have put in place.
Yeah, that's right, Emma. That's in fact, it's quite the opposite, isn't it? Because the government has made it very clear and made it very clear from the outset of the introduction of the JRS, the Job Retention Scheme, that this would represent a contractual change, even a temporary one. And it said that in its guidance that this would be a status change and a pay rate change, and this would require an employer to comply with the established principles around changing contracts of employment and contractual terms. So the right to recover some sums via the furlough scheme did not give the employer the right to make changes to contracts of employment or provide a different mechanism for doing so.
Absolutely. And, whilst we have seen that some of our laws have been impacted by lockdown or seeking to claim under the job retention scheme, or, just in sort of practical terms, haven't they, around, virtual meetings, the use of communication, or in fact the speed with which employers have had to make these changes. Yes, there have been some changes there, but as you say, Andy, the sort of mechanism has not changed. But no doubt what will be created when we look to the future and we look at workforce planning is that there is a potential for there to be an increase in tensions between employers and employees. And in these strange times, employers I think, cannot assume that their staff will simply accept any change that is imposed. And certainly as a team, we're seeing that employers are still receiving complaints, they're still receiving grievances, and also claims are still being made by employees. So at a time when businesses need to be focusing on the future, their future changes, their future workforce planning, it would be wise not to have to spend time having to deal with complaints and claims. So let's have a think about changing individual contract terms. An employee's contract terms will usually alter during their employment, and most changes will be uncontroversial. But sometimes employers want to do something that the employee is less willing to accept. In such cases, the employer must know how to make those changes legally binding, while, of course, as we've said, minimising complaints and claims and minimising disruption. Unlike a non-contractual employment policy, so something in a handbook or on the intranet, a contract or a contract term cannot be amended unilaterally, or can only be amended in terms with the terms itself and also with what the contract says.
Yeah, so when we talk about changing a contract of employment, we're concerned really about fundamental changes, not to minor and trivial ones. So fundamental changes concern changing the terms upon which a person initially agreed to work for you. So that could be around their pay, maybe the benefits that they receive, the hours they're expected to work, or possibly also the place that they're required to work as well. Also, you need to think whether the change involves altering the deal that the employee originally agreed to. So are you increasing the business protection clauses by adding restrictive covenants in, for example? And that's a slightly unusual set of circumstances where you might have to pay some additional form of consideration. So give the employee something in exchange for agreeing to those new restrictions.
And sometimes the contract itself may allow for some kind of variation. For example, a contract of employment may allow an employer to change a person's place of work, provided any relocation is not unreasonable or too far away from where they currently work. So it's really important before employers propose any change to read the contract and see what sorts of clauses you want to change, and see if there's any scope under that clause, whether there's any flexibility, but also remembering that there are limits and there are risks in exercising that discretion. Also, plan ahead. What are you going to do if the employee does not agree to the change or the contract variation? Will you simply accept that that employee is not going to accept the deal, or are you going to look at doing something a little bit more radical around dismissing and re-engaging, because that's really going to have an impact on your business planning? Okay, so when you're looking at the contract of employment, it's really important to understand what types of clauses that there are under the contract, isn't it, Andy? So if you could just talk us through what some clauses are that people will have in their contracts of employment.
Sure, of course, and it is important to understand and appreciate the clauses that exist and appreciate the different rules that apply in your abilities to potentially amend or vary them. So the first clauses that we may encounter are express clauses, and these are set out in the terms and conditions of employment, so things that are written down, and they will often say expressly that something either will or will not happen. So something like notice periods would be a good example of this. So if the employer or the employee want to end the employment relationship, they have to comply with a notice period, whether the contract simply states that it's the statutory minimum notice period that applies or something that's a bit longer. So these sort of express terms which provide a specific right or a specific obligation that something will or won't happen, as a general rule, you can't change those unilaterally. You can't, therefore, as an employer, impose that change upon the employee without their consent. And if you seek to do so, that might result in some further consequences that will arise as a result.
So the next type of clause are ones that we're going to call give that sort of element of flexibility. And often you get a mixture between an express clause, an express term, with a bit of flexibility thrown in. So you have a clause, for example, with regards to place of work, which will typically say you will work at place X. So this is an express clause, an express intention. But then, we tend to throw in a bit of flexibility where the employer reserves the right to change the place of work within either a reasonable geographical range or commuting time. So Andy, when we have either these pure flexibility clauses or these sort of mix of bit of express and a bit of flex, how do they work in practice?
Well, not as simply as you might think. They do create some challenges because on the one hand you have a contractual expression of certainty, so you will work at this particular location or you will do this, but then at the same time the employer reserving the right in the contract to say yes, but we might change that, which does go against the sort of the fundamental ideal behind a contract of employment, that it's supposed to be a bargain, a bilateral agreement between two parties, without the ability of one side to just flex it however they may choose.
So, employers, need to remember, don't they, that even though there is this flexibility within the clause, it doesn't give them, carte blanche to do what they like and change what they like when they like.
Yeah, absolutely, because there is this balance. So, should an employer seek to rely upon a flexibility provision, so for example, looking to move someone's place of work, and the employee complains about that, and a claim is made to a court or a tribunal, then what would be considered is the rationale behind the change, but also how it was implemented, and was the implementation reasonable? Was there some explanation behind the change? And the more fundamental the change is, the harder it will be for the employer to rely simply on, well, the clause allows us a degree of flexibility. So we also have clauses which give some discretion. So you might have an express clause which says something like, you can join the company's bonus scheme, but anything you earn is essentially up to the employer, and that gives the employer the discretion to either award something or not, at least in theory, according to the contract. So, a court will look at how those purported flexibility provisions are actually operated in practice to take a view on the enforceability and how that discretion or how that flexibility is being operated by the employer.
And I think, when we think about the change of location clauses, and that's a really good example where you have this balance between, allowing the employer that flexibility within the clause to make these reasonable changes. But actually, if the place of work is closing or there is a sort of a fundamental change, it can actually lead to a potential redundancy situation. So again, it's really important to take advice and test out the limits, isn't it, on this flexibility. And again, when you say there, Andy, about bonus clauses, where there is this element of discretion, it's discretion is not absolute, and there's lots of case law around how employers can exercise this discretion. So really useful clauses to have, but remember that discretion cannot be exercised unfairly, cannot be exercised in a way which discriminates or which could be described as being irrational or capricious. So I think some really good sort of takeaways there. Flexible clauses, brilliant, but there are limits to that flexibility, to that discretion. The next set of clauses, well, they're not really clauses, because they're not written down. But then we have this sort of this type of clause around implied terms, these unwritten terms, these unwritten rules of engagements, Andy. So what can you tell us about implied terms?
Well, so some of them will have been established as a result of case law over the last few hundred years, where a case has been considered and the courts have decreed that into every contract of employment there'll be a particular clause, so the duty of fidelity, for example, between the parties. And another one is the implied term of trust and confidence, and that does have an interplay with the flexibility in the varia and the discretionary clauses that Emma and we were just talking about, because of course, even if you have an express term that gives you the right to do something, if you operate that express term in an unreasonable or capricious manner, then that might give scope to the employee to say, well, you breached the implied term of trust and confidence between us. So yes, you had the right to move my place of work, but telling me on the Friday that the following Monday you require me to work in Glasgow, whereas previously I worked in London, well, you might have the contractual right to do it, but the way that you're doing it is in breach of the implied term of trust and confidence. It's an unreasonable way of going about doing this. In addition to those sort of implied terms, you've also got ones which they simply exist because if you were to ask the employer and the employee whether such a term applied to the employment relationship, their response would be, well, yes, of course they do. Yes, it's a mutual understanding that that would be the case. So, Emma, we've got some examples of those, haven't we?
Yeah, and I think, those sort of course clauses are things, around sort of health and safety. Yes, there are obviously statutory obligations, but that sort of implied obligation to protect the health and safety of your people whilst at work, that's one of these. Of course we have to do that. And I think, absolutely the trust and confidence point's really important, particularly when you talk about changing terms and conditions of employment, as well as in, the sort of the way that employers and employees interact with each other as well. And again, that's one of those sort of clauses that underpins, fundamental to the employment relationship. You can't override an implied term, so an employment cannot do what it likes and argue that, well, trust and confidence is simply just an implied term, I don't need to worry about it. Absolutely not. They are fundamental to the relationship. And I'd also add there statutory clauses as well. So those baseline clauses, baseline terms around national minimum wage, national living wage, statutory benefits, holiday, notice, statutory minimum notice, they are sort of, the minimum. So employers cannot go below it, but of course they can enhance those benefits as well.
And then once we've dealt with those implied terms, then we look at things that are perhaps slightly less controversial, and we talk about the sort of minor tweaks and administrative changes to people's contracts of employment. So we're talking about things, maybe the payroll date and when the payroll is run. Now that might potentially be of significant significance to your employees if their mortgage payments go out on a particular date, but provided there's sufficient notice given and people are able to put their affairs in order to make sure that that's accounted for, then as a general rule it's a relatively minor administrative change that even if there was an express term that says we're going to pay you on such and such a date, it's unlikely to cause that much controversy, and it is just a sort of an administrative tweaking around the way that you might operate in a particular set of circumstances.
But I think still really important there to have that certainty and clarity and to put that into, into writing as well. One thing that I think we've seen lots of it, haven't we, with our own clients and in the, sort of general media as well, about reporting about how employers are coping and dealing with things at the moment, has been around the temporary change of contract. And that's been a really big question that we've been looking at as well, hasn't it, Andy, with our own clients?
Yeah, that's right. And with the introduction of the job retention scheme and the decision of many employees, the decision of many employers to place employees on furlough, then this was intended by the parties to be a temporary measure. So that was, this wasn't supposed to be a forever provision. It was something that was going to last for the duration of the JRS to help the business out and to look to recover some remuneration from the government. In addition to that, we also saw some other variations, such as businesses putting a stop to overtime on a temporary basis, and other measures, maybe employees agreeing to reduce their hours or reduce the number of days they work. But it's important to decide obviously whether the change you're looking to implement is going to be a temporary one. And although much of the formality around permanent changes still applies, and it is right that there is a formality to it, it's really important to remember that this is intended to be a limited time, for a limited time period only, if that is the case. Or if not, is there a review process in place? What are the triggers going to be to either change those back to the normal terms or to persist with the terms that have been agreed?
And I think, whether employers are looking at a permanent or a temporary change, it's always best to bring people with you on the journey. So communication around all of this is going to be really important. So, is the change temporary? What are the conditions for this change either to end? So are you going to say for a period of X months, we are going to reduce hours or reduce pay? Or is it going to be that, we will keep it reviewed, and allowing that period of time for employees to consider and also to accept is really good practice. I think the other thing with temporary changes and this idea that, we are going to keep it under review is not to promise too much, because, things are changing really quickly at the moment and there is a lot of uncertainty. So just, be careful that when you are saying, we are going to do X, Y, Z, just think how realistic that's going to be in the current climate. We can still consult, we can still communicate, we've got virtual ways of doing that, virtual surveys, e-signatures. So there are ways for employers to be able to get employees on board, to tell them, explain to them what's going to happen. So, there is a way to do that.
Yeah, absolutely. What's going to be very important is that we do record the conversations that we have. I don't mean physically record them as in, by way of some sort of technical mechanism of recording what people say, but making sure that we've got a note of what's actually being said. Notes are really important around internal decisions of this nature, and making sure that it's properly documented as to what has been agreed as far as a pay reduction or a reduction in hours, for example. So remember as well that in considering if a change is going to come to an end, that we have to make decisions fairly about how that's going to happen and who's going to be affected and in what way. We need to ensure that we're not discriminating, for example, in any of those sort of decisions that we're making. So if the employer is proposing to end a temporary change, even when it's advantageous to the employee, for example, going back to normal pay and conditions, it would be wise to ask the employee to agree to this change. So a good example of that might be, for example, where people have been on furlough and we're now looking to return people to work. You would have thought for most people they'd be very excited about that prospect, and therefore they're going to be receiving additional pay. Pay would go back to normal, and isn't that a good thing? But for example, if someone has childcare responsibilities and the schools are of course still closed and won't be open again until September, they simply may not be in a position to return to work. So we do have to be mindful about properly consulting with people about amending or flexing or returning to normal terms and bringing temporary arrangements to a conclusion.
Yeah, absolutely. And you're right, being as flexible as employers can be at this time, I think, and communication, keeping that going is going to be really key and crucial to getting people, taking them with you. So when we talk about, changing terms, so let's have a look now to our express terms. Maybe pay. What is it? What is that gold standard, Andy?
Okay, well, I think if we're looking at a situation where we're proposing to change individuals' express terms in their contract, so we're talking about a fundamental change here, then we really need to carefully plan in advance how we're going to conduct this program and how it's going to be rolled out. And we've identified on this slide a sort of 4-stage process that runs from initially discussing the proposal to the employee then hopefully signing the new terms and those terms taking effect. Now, the longer that you can allow for this consultation process, the fairer the process will both look to the employee, which is always important. I often say to people that it's important for a process to look fair, not just be fair, because you want to convince the employees that what you're doing is lawful, and that will reduce the risk of complaints or claims arising. But depending upon the change and the business that you are in your particular circumstances, that consultation process could be, for example, maybe 2 to 4 weeks long. It could be longer depending upon the circumstances. But once you've set in your mind and you understand what the timetable looks like, stage one is going to involve that initial communication with the employee to discuss the proposed changes, what they look like, and when those changes would take effect. This could be done by letter or a remote meeting. In the olden days, we might have had a town hall meeting of some description. Of course, I suppose you could still have a town hall Zoom meeting potentially to make an announcement, depending upon what your workforce look like and your connectivity and your ability to engage with individuals in that way. Then stage 2 or 3, the managers or HR support might want to meet with the employees again. This time to discuss any questions or concerns that the employees might have as part of the process, whether they be about the process itself or whether they be about the changes that you're looking to implement. Having said that, of course, you might find that the employee or the employees in question simply sign an acceptance letter or the new contract, and you just get it back, and they're not interested in having a dialogue with you, which obviously would be great from your perspective. But I still think it's a good idea in those circumstances to exchange a quick email with the individual to give them the chance to meet up with you, even if they're looking to accept the change. Because again, we say this so often, we almost bore ourselves by saying it, but communication and evidence of communication is really important. Should there ever been issues that arise at a later date, you want to be able to show that you have engaged, that you have had discussions, and that you have a rationale for the decisions that have actually been made.
And I think the other point is that, it's also important for employers to be upfront with employees and say, if you don't accept, this might happen. It might be, consequences individually or negative impact on the business. So I think, it's important to also be, communicative and also talk about what might happen to individuals in the business as well. But again, this is the gold standard approach. And, when we talk as well about, flexible and how do we look at changing those flexibility clauses we've talked about, or where we have that mixture of express and flexible, are there any changes there to that gold standard approach of consultation, Andy?
Well, it does depend upon the clause, what it says, what you're proposing to change, and whether or not that's included in the scope, and whether the clause actually fully permits you to do this. So to think of an example, if the employer was looking just at a minor change, so for example, a salary increase as part of a review, a simple letter to the employee explaining the change, and if necessary, some time to ask questions, and would then requiring the employee to sign and return a letter, well, that's pretty straightforward. You don't imagine there's going to be much pushback about that. But there are, of course, degrees regarding flexibility. We've already given some examples of that. It's always going to be a question of fact and degree, taking into account individual circumstances as well, and whether the clause is just a tweak around the edges of something that's already done, maybe putting into writing or agreeing to a change that already is de facto what happens, or whether it's something that's more fundamental. And the greater the impact that the change is going to have on an individual or the employees at large, then the greater scrutiny there might be about the process that's been followed and the fairness of the process that you've run.
And I think that's a really good point, Andy, that you just made around, we can change a clause and it might, impact individuals differently. And I think it's really important that when you're looking at contract changes, that you don't just focus on the sort of the group or the team or the employee population as a whole, but also think about how individuals could be impacted by that. And I think, when we talk about changing the place of work, that's a really good example where different depending on where they live and their circumstances at home, how that can impact, differently. And as well, as we said, is this potentially a redundancy situation? So again, it's really understanding that, yes, flexibility clauses are great, but also we need to think about it in terms of, the fact and degree, as you've said. So would you say then, Andy, that it would be wise to go through the sort of the gold standard approach if you want to change a flexibility clause?
Well, I think it is going to depend upon the change that you're looking to implement, the scope that you have within the wording of the clause to make those changes, and the impact of the change. Also, frankly, another factor to take into consideration is commercial issues, and also your attitude as a business towards risk. Sometimes businesses choose to make changes or to implement changes in relatively short following relatively short processes and in a short time scale, because there is a pressing business need to do it. And it's recognized that maybe you're not following an ideal standard, but there's bigger concerns, frankly, for the business, and therefore on a commercial basis, that's a risk that you're willing to take to follow a process that is less than the gold standard, but that frankly you feel that it's necessary to do that. Also, to be hugely cynical as well at the moment, many businesses, perhaps at the time of the last downturn in the late noughties, many businesses pushed through changes to terms, conditions, and relied upon flexibility clauses to change people's terms, conditions, with the view that the employees just weren't going to complain about it, because frankly their job was worth more to them than complaining about either the change that was being imposed or the way in which it was going to be imposed or changed rather, and therefore they almost dared the employees to complain. So I'm not advocating that as an appropriate way to proceed in all circumstances, but clearly commercial circumstances and attitudes towards risk will also be a factor. My sort of lawyer's hat advice, though, is that it's always wise to undertake a form of consultation process, allowing for the opportunity for there to be review and reflection by the employee about what you're doing and why you're doing it, and giving the employee the chance to sign something at the end of that process to confirm their consent.
Absolutely. And, when we talk about consultation, those eagle-eared and eagle-eyed listeners amongst you have joined us for various webinars and reading our articles will have heard me talk about collective consultation obligations, and talking about it in the context of changing terms and conditions of employment. Obviously we know about redundancies and numbers, etc., but there is this wider definition of redundancy in the definition of redundancy under the legislation, which talks about dismissal and re-engagement. And so it's important, isn't it, that when you are planning and looking at changing terms and conditions, you need to decide what you are going to do if the employee does not agree. And what will this mean in practice? Are you as an organisation going to accept that employees won't agree to the new deal, to the new term, and just move on with people on different contract terms? Or actually, are you going to look at dismissing and re-engaging? And we need to then think about what the consequences might be of that. And if you can just sort of talk us through those, that would be really helpful.
Yeah, of course. So the magic number here is 20. So that's 20 employees who may be affected by the change. So if we're proposing to change the terms of contract of 20 or more employees, and if the employees do not provide their consent to that change, and we in those circumstances may choose to dismiss and re-engage those employees, if they do not give their consent, then the collective consultation obligations under the TULRACA, the Trade Union Labour Relations Consolidations Act, will be triggered, which means, as Emma has mentioned previously in other circumstances, collective consultation and collective redundancy obligations will apply. And that will mean that employers would need to consult about the contract changes with elected or appointed staff representatives for either 30 or 45 days before the first dismissal can take effect, as well as incorporating some individual consultation as well. And the other thing that would need to be done too is that a Form HR1, which some of you may have had some experience of in the past, would also need to be filed with the Secretary of State. Now, this may all seem slightly odd because, of course, the intention for the business in these sorts of circumstances is not to lose anyone. What you're looking to do is to bring to an end the contract that currently exists with the employee, but then the employees to all then sign the new terms and conditions. So you're not looking to reduce headcount, you just want people to stay but be employed on different terms. But the definition of redundancy under Whittaker has been found to be wide enough in many cases, case law has found that the definition of redundancy under Whittaker is wide enough to include dismissals and re-engagements of this nature, triggering the obligation to collectively consult.
So this is going to take some planning, and also it is unlikely, even given the current economic climate that many businesses find themselves in, that the defence of special circumstances for most employers will not apply. So even in these difficult times, employers will have to do something, will have to reasonably comply with their obligations under the collective consultation obligation. So it is a heads up. It is something to be aware of. Be aware of those consequences and what might happen if employees do decide they are not going to accept the change. And also, when we've talked about risk and factoring in the risk, remember that, under the collective consultation obligations, then, there is the protective award claim. So again, it's something to think about when you're looking at your planning.
Yeah,
absolutely. There are a couple of other issues, aren't there, Andy, on this collective consultation, or actually other obligations to consult that we need to sort of flag.
Yeah, absolutely. I was just going to say about the collective award for those that don't know this off the top of their head. It is up to 90 days uncapped pay for each employee where there is a failure to comply with the collective consultation obligations where they arise. So it's not something to be dismissed lightly. And also, strictly speaking, it's a criminal liability for a failure to file a Form HR1 as well with the Secretary of State. So these are obligations with teeth, so they're not to simply be ignored. But yeah, on your point, there are some other issues to flag up, which are perhaps slightly beyond the scope of our discussion today, but it's important to remember them, and that you may have a collective consultation agreement or other sort of or other information and collective consultation obligations under an agreement that you have in place, whether it be with a recognised trade union or whether it be just with an internal works council. So you do need to check out what it says in your agreement, should they exist, about how that process will be conducted. Also, it's worth remembering that our friend 2P and the limits that this places on new employers and their attempts to try and change contractual terms after a service provision change or a business acquisition. In addition, if an employer is proposing to make changes to pension arrangements, then there are pension regulator obligations to consider too. So if your business has any of these specific peculiar or unusual circumstances and it's looking to make changes, then specific legal advice is advised, frankly, to make sure that you do comply with all of those obligations. Finally, it's also important to remember that it will be necessary to give notice to terminate the original contract if you're looking to dismiss and re-engage. So if you did want to bring about a contractual change and you had to rely upon the dismissal and re-engagement process, then this is not going to result in an immediate change to the terms and conditions of the employee. So if, for example, an employee has a 3-month notice period, then it could take you between maybe 4 to 5 months, perhaps even longer, to bring about a change to their contract, because you would need to go through the consultation process to begin with, and then also give the employee notice to terminate their contract, whatever that notice period might be, before the actual change is implemented. So once you factor into both those consultation and notice periods, it can take quite a long time to actually get a change over the line.
Yeah, and it's part of that sort of planning, isn't it? The devil with most things in employment law or employment related is, you know, the devil is always in the detail. So let's talk about now the actual physical acceptance of a contract change. And you know, we've talked about that employers, certainly with express clauses, cannot look to unilaterally change a contract. But Andy, you know, how do we get employees to agree?
Okay, so when an employee starts working for an employer, they're given a document that's often entitled contract or terms, conditions, or written particulars, whatever it might be. And we would ask them to sign it and return it to us. But of course, when we're looking to change one of the terms in that contract, we're still asking the employee to accept a new deal. And as we've discussed already, that changes that we might seek to unilaterally impose would represent a breach of the contract. So as a result, that means that if we're not relying upon flexibility and we are looking to change something by consent, then the employee needs to agree to that new offer. So in basic contract terms, we're talking about us making an offer and the employee accepting that offer. It's often easy in the case of a salary increase or a change of role to evidence that that change and for that change to be implemented, because the employee might be quite happy to take that increase in salary or that change of role, certainly if it's promotion. So it's unlikely they're going to complain, but we would still want, if we can, to obtain some sort of written or documentary or evidential form showing that there has been acceptance of the variation.
And what about verbal acceptance?
Well, in theory, it would work. You can accept an offer verbally, but it's not advisable. And that's because memories can fade, or a party can change their mind later on and deny having agreed to the change in question. And if you don't have anything in writing, you can't evidence that it was actually agreed. So it is important to keep records of meetings with employees where you're looking to discuss any new contractual terms with them, and follow that up with getting a signed copy of an acceptance letter, if you like, confirming they've agreed to the changes.
So when we're talking about using our contracts as well as more strategic, as business protection tools, and perhaps, you know, people are being promoted, we want to look at maybe giving them a longer notice period, or we want to use post-termination restrictions. Again, these are sort of quirky clauses. You're asking people to accept more than they initially bargained for, you know, part of the original deal. So in these sorts of circumstances, we would need to offer some separate payment, some form of consideration, which is the legal term, offer acceptance consideration, you know, the fundamentals of making a contract. So if you are looking at changing those business terms, increasing those business terms, yes, we need, you know, to have that in writing, but also we need to think about consideration as well, because we want to make those clauses as enforceable as possible. But we know, don't we, Andy, that that's not always possible. You know, we've consulted, we've done all this great stuff, our virtual town hall meetings, etc., but we don't get anything back. So can employers imply acceptance?
Well, I mean, it depends on the circumstances and what the letter that you've sent to the employee is asking for in terms of acceptance of the change. So, for example, does the letter simply say, well, unless we hear from you by X, Y, and Z or a particular date, we'll take that as acceptance? Another factor could be the employee's conduct. So are they acting like someone who's accepted the change? So if you promote them into a new role and they start doing that new role, well, then you can perhaps say, well, by your conduct, clearly you've accepted that change. And the longer an employee carries on working under the new terms without any form of written dissent at all, then this can be taken as acceptance, even without signature or other acceptance in written form.
So what's important is if there is going to be a protest, that protest has to be clear. And certainly actually a really good and timely example of silence and implied acceptance actually happened very recently with the Carluccio's restaurant chain, and this actually involved the job retention scheme as well, so really topical. So in this case, the High Court was asked by administrators for Carluccio's to look at how it was proposing to change employment terms, because what the administrators wanted to do was to access the job retention scheme for certain employees. And so what the administrators did was they wrote to employees, didn't they? Andy, if you want to just take up the nature of that case there, what happened when they wrote to the employees?
Yeah, sure. So on the 30th of April, Carluccio's employees received a letter from the administrators offering to continue to employ them as furloughed workers so that it could then take advantage of the JRS. And the letter said that the company did not have the money to pay their wages now, but it said that as soon as the funds were received from the government, it would be able to pay them in respect of the backdated furlough leave and the pay that they were due. So of the 1,788 employees who received the letter, 1,707 consented to their contract being altered. Excellent. 4 rejected it and said they wished to be made redundant, and 77 didn't respond. In the case before the High Court, the Carluccio's administrators asked what should happen with the 77 employees who just hadn't responded at all. Were they able to claim for them under the JRS? Had they consented to that change? So Emma, what happened next?
Yeah, suspense. So what's really sort of important in this case is 14 days. So the administrators allowed these 77 employees 14 days with which to come back. Now that 14 days is important because under normal insolvency rules, administrators would dismiss workers after 14 days of their appointment to avoid having to pay wages, etc. So what should the administrators do? Should they take the employee's silence of having accepted furlough and put them on the JRS, or should they dismiss them? But the High Court ruled that it was in the interest of the company and the employees to allow an extension of this 14-day period, to allow those 77 silence employees to actually come back and confirm what they wanted to do. And the Unite Union, which was also involved, was obviously urging employees to respond if they hadn't done so already. So a really interesting case, Andy, and one, timely, obviously, with what's been going on, with the job retention scheme as well.
Yeah, and it does really highlight the need for clarity in letters seeking agreement, not just in the administration process, but if employers are wanting to use letters to ask for agreement to changes, it needs to set out a timetable for acceptance and also explain what the employer will and will not do if the employee is silent and just doesn't provide a response.
And again, the employee that won't sign, it's a problem area, isn't it, for employers? Obviously, not just in the administration field, as you said, Andy. So, what advice can you give to employers in this scenario?
Well, obviously, an employer can't force an employee to sign a new contract. Or require or compel them to accept to a new contractual change. An employee has to be willing to work for you under agreed terms. However, if you do find yourself with an unwilling employee, it's important to ensure that it is business as usual with them and that you don't single them out as being difficult or obstructive. If you do think an employee will be difficult, then it's better to act sooner rather than later. So if the employer could offer further meetings or a chance for the employee to raise their concerns higher up the managerial chain, or if they're looking for particular reassurances, which once given might convince them to sign up to the contract.
And I think that's a really important point, isn't it? Is to find out exactly what's been, what has happened, why the employee won't sign, and as well as our employees who are completely silent, we then have our set of employees who are working under protest. So again, what sorts of strategies can employers use with our working under protest employees?
Well, from a legal perspective, an employer wouldn't want to rely upon a contract being binding simply because someone has continued to work for you, notwithstanding you having given them a new term. So if an employee doesn't agree to the change, but doesn't inform the employer and they work under the new terms and conditions, then you could argue that they've accepted the changes. There have, however, been examples of cases where employees have objected expressly to contractual changes for many years, and many years after the event, despite the fact that it didn't appear that they were complaining or disputing or refusing to accept the changes at that time. So much is going to depend upon what objections, if a court ever looks at it, what objections the employers actually raised at the time, and whether it can be said that the employers actually agreed to the change by their conduct. So whether you can say, well, the way that they've conducted themselves does demonstrate they've accepted it.
And again, that's why it's really important, isn't it, to have, communicate with employees about what you're doing and why you're doing it and the consequences of that. The other, sort of extreme case would be where, despite consultation, again, employees resign. And again, what are some of the risks there, Andy, and what sort of considerations should employers give in those situations?
Well, that could give rise to claims in the tribunal, whether someone might look to pursue some sort of constructive dismissal claim, or if they're going to argue that they've been discriminated against in some way, shape or form. So you'd like to avoid it if at all possible. So if they do refuse or if they do resign, give them a chance to reconsider. Sometimes a decision is made in haste. And once they've been given a chance to consider it or cool off a bit, they may change their mind. Also, as much as we don't like to encourage people to raise grievances all the time, the grievance route is available to them, and that might give them an opportunity to have their concerns considered by a different manager and to be talked through, and for hopefully a resolution to be reached.
Yeah, and claims for constructive unfair dismissal. So I've been forced to resign. It's where obviously the interplay of that implied term there of trust and confidence comes into play again. Those with 2 years service obviously have the right there not to be unfairly dismissed. Discrimination, and as you mentioned there, obviously that's a day one right. And then obviously we have issues there of unlawful deductions from wages. And could perhaps this area of claim be more advantageous to employees?
Well, potentially, yes, because we're talking about, we just mentioned a scenario where an employee may resign because of the changes that you're imposing. But could an employee potentially just decide that they don't want to resign, or maybe they're not in a position to resign because they need their job, but could they stay and sue? So if what you're doing has maybe resulted in a reduction in their salary, could they bring a separate claim for breach of contract or unlawful deduction from wages, arguing that although they remain unemployed, they're receiving less than they're contractually entitled to receive, and look to pursue that money through the courts or tribunals? I mean, that's an option that's available to someone potentially.
So just to sort of sum up then the possible solutions that we've talked about, communication's really key, negotiation, but obviously, it's still the employer is still making the decisions. Can we offer something different? Can we be flexible? Can we ask the employee to take their own advice perhaps? And we've seen that happen, or depending on the circumstances, can we give the employee more time? And obviously we've talked, haven't we, about dismissing and re-engaging, and as well, we need to think about how we do that. We've talked as well about collective consultation. So again, just something there for the employer to be to be aware of. And then, Andy, you made the point that you have to dismiss under the old contract and the timings around that before re-engaging under the new one. And I just want to focus, sort of forward thinking as well, Andy, about how can we use our contracts of employment, more strategically, and I think now is a really good time for employers to look at their contracts of employment and see how we can use them more effectively. And certainly in the contracts that I've been looking at for clients, focusing more on those short term, those layoff clauses, which fell out of favour, still around in sort of manufacturing, in the manufacturing sector, but certainly in the services sector, the technology sector, were clauses that employers didn't have. Another area would be sort of around holidays and holiday pay. So do we need to think about other, other ways in which we can use our holiday pay clauses, more effectively? And I wonder, Andy, if there's any other clauses that perhaps you're seeing employers are asking you more to include in their own contracts.
Well, as I'm sat here in the spare bedroom at my desk, it makes me think about remote or home working, and whether it's a good idea to look again at our provisions, our contractual provisions about place of work, and looking at flexibility around where someone may be able to provide their services to you. It's always sensible to have a specific office location identified. Indeed, the Employment Rights Act requires you to identify a specific place of work. But think again about whether or not those terms can be flexed slightly to allow for or amended to allow for other ways of working, and also think about the policies you might need as well. I know there was probably a lot of rush back in early April, people looking at their policies, understanding what they needed to do, how they could enable their staff to work safely and securely around the home or away from the office. Well, it's a good time to think about all of these things, isn't it? About data protection as well, using employees using personal devices for their work, and just health and safety if someone's sat at home working rather than at their beautifully ergonomically designed desk.
Yeah, and linked to that is obviously the clauses around business protection. So confidentiality, a big issue, particularly when people are working remotely. How can we protect that information? IP as well, other good clauses there. But also, as we sort of, as markets become more competitive and companies look to keep hold of employees and those key people, perhaps, now is the time to look at using our contracts of employment more effectively. So thinking about, business protection clauses, poaching employees, poaching clients. It's really important to think about, business preservation as well. And the other point would be training on contracts. Do your managers actually understand the importance of some of these terms and what they actually mean in practice and how they can use them? So you can try and keep managers on the same page as HR. So just some practical points there, just to sort of finish up. These are indeed exceptional times, and as part of business planning, the devil is always in the detail of any change program that you're wanting to introduce. So allowing that time to consult and for that consultation to be meaningful. But your managers are also really key to the success of this program, this change management program, be it a policy change or a contract change. So it's really important that your managers understand the reason for the change, so they can impact positively on the messaging to their team.
Yeah, that's right. And I think the only thing I'd add to that, Emma, is that get HR involved early on in that process. So that appropriate planning could be made, and just clarity as well. Be clear about what it is that you're doing, why you're doing it, and what you want of the employees and what might happen if consent isn't provided.
Absolutely, setting that timetable, whether it's a redundancy program or a contract change program, it's really important. If you do your homework to start with and you get your communication all planned out and everyone's on board with the messaging, it really does make managers' lives, HR's lives, much easier, because you know what's going to happen if things don't go to plan. You've worked out all your sort of risk assessing in your plans there. So, view it positively in the spirit of taking the employees with you on the journey. Just a reminder that we do have lots of information on our COVID Business Hub. So again, check out our website, lots of information there, lots of articles there. Our podcasts and our previous webinars can be found there as well. And again, the employment team is open. We are very much open, aren't we, Andy? So,
Absolutely,
please
yeah.
do come back to us if you've got any questions. Just one quick question, Andy, that we did have come in. This idea of giving notice under the old contracts and re-engaging under the new contract. Can employers, just put you on the spot, Andy, can employers use a pile-on clause if they've got the ability to, to pay in lieu of notice? Does that sort of help?
Well, contractually you can, but I'm not sure you'd want to, would you? Because then you'd be paying your staff double salary. So let's say someone's on notice. Let's say someone's got 3 months notice. Well, you then have to terminate that notice by making a pile-on payment. So you have to then give them 3 months pay, but they continue in their employment under the new contract, and they're entitled to receive pay under the terms of their new contract. So what that would mean is you'd be double paying them for 3 months. So yeah, in theory you could, but I'm not sure it's advisable.
No, and also, you want to presumably keep that individual as well. So yeah, I think that's a good advice there on the pile-on pay point. So thank you for that question that came in. We've had a couple of more that are more sort of business related, so we will look at those. We'll look at those individually as well. So that only leads me to thank you very much for joining us today, and my thanks to Andy as well for joining me on the podcast.
Pleasure as always.
On the webinar. Thank you. Brilliant. Okay, thanks so much. And we will be in touch with our programme for August, September and October as well. So lots of exciting opportunities for you to meet us virtually and get involved in the discussion as well. So thank you very much.
Thanks all.